Okay.
8. Got it.
Sorry about
No worries. So a negative easement, again, is often referred to as a servient estate. So you will see that. Oh, we got someone. I'm going to admit them. Perfect. You will also often see that when that piece of property or that estate is the one that has the easement on it. It's known as the servient estate because it's being burdened by allowing other people to go ahead and access that piece of property. And then we have an affirmative easement, which you'll see you have the benefit of using another owner's land. So that's when you're considered the dominant estate. And sorry, let me just preface this. I'm looking at the people, but my camera's right here. So let me more look at the camera so it looks like I'm looking at you. So that's often a dominant estate, and that's when you have the ability to go ahead and access that servient estate. So your property is not necessarily being burdened. You are allowing to go onto someone else's property and use their property. So you would essentially be the easement holder. All right. The difference between a gross and a pertinent easement. So again, easement is generally used all the time, but there are specificities behind it. And here, I'm going to add someone else right here. Sorry. So an easement in gross is a personal easement and does not run with the estate. Often has a servient track, but no dominant track. So what you'll see here essentially are when utility companies have easements, right? So there's a property, let's say a house has a utility easement on it, and we'll touch on that a little later, but that is a servient estate, right? The house is being burdened by allowing others to access it, but then there's no dominant estate because there's no other property being like essentially needing the use of that easement. It's actually a company, it's the utility company. So it's the company being allowed. So that's where the personal easement comes into play, right? It doesn't draw to any land, but it's to a person or a company in this instance, which is the utility company. Now, compare that to an appurtenant easement, and the appurtenant easement is often what you see when, you know, you have neighboring driveways or something like that, that it maybe goes a little bit on someone else's property, or you can't access your garage unless you can use the other person's property, stuff of that nature. That's when the easement runs with the estate and has both a dominant and servient tract of land. So again, dominant is the affirmative easement. You have the benefit of using someone's land, and the servient is the burdened easement. That burdens that property. All right, locating whether an easement exists on a property. So this comes into play. Let's say you have, you know, this house that your clients want to put an offer on or something, and the garage is in the way back and there's no way to access it. And you're like, well, what's the point of having this garage if they can't park their car? Let's go see if there's an easement maybe where they can go ahead and use the neighbor's, you know, gravel driveway to swing and go into the garage or something like that. So how to locate whether that does exist. Land records within the circuit court of the jurisdiction wherein the property lies is where those easements will be recorded. So you'll essentially want to look there. It's in the clerk of court. And then land records are responsible for recording easements wherein a plat or survey will show the easement. And generally that plat or survey is attached to a deed and recorded simultaneously. Again, we'll touch on all this a little later on, but this is big picture of how you can go ahead and determine whether an easement exists. Now, if an easement doesn't exist and you want to create one, we're going to touch on that too a little later. All right. Now, when would be a time you may not be able to find an easement within land records? Does anyone have an idea on this? So essentially, if an easement is created by adverse possession, in the easement world, so in legal world, adverse possession is when there's been an open and notorious continuous use of an adverse piece of land that you're not necessarily owner of for longer than an ascribed period of time. In the easement world, it's called easement by prescription, which is essentially an easement by adverse possession. In that regard, it wouldn't necessarily be recorded with land records because it's not an agreement of the parties. It's by adverse possession that that easement created. So that is something to think about.
Now, is it true that adverse possession is not as straightforward as it might seem, and it's actually a lot more difficult to claim adverse possession because it has to be a certain amount of time and all sorts of different legal complications?
Great question, Jordan. Yes, absolutely. Adverse possession is very hard to prove. The terms of it are open and notorious for an ascribed period of time against the interests of the owners for a continuous period. And what's really hard to prove is whether or not the other person knew and had, you know, so the open and notorious is the other person knowing and having actual knowledge or constructive knowledge that this was occurring. So how do you necessarily prove that when you probably have the adverse party saying, no, I knew nothing of this. It wasn't until XYZ brought it to my attention. That's why I'm taking action. So that aspect is hard. It's also hard too when you do have a lender involved, because that property is essential. The lender has a security interest in that piece of property. So if an easement is going ahead and affecting that property and burdening that property, some lenders may feel that their fair value of the property is being diminished. So you have aspects there too, where lenders try to go ahead and interject themselves and do an interpleader, which this is probably a lot of legalese that you guys don't need to be bogged down with. But yes, Jordan highlighted it is very hard for adverse possession claims. Not impossible, they do exist, but it is hard. And you just need to make sure you check all the elements because it's very element driven. All right, so now we're going to talk about the code section that applies to easements. So we kind of highlighted some of the vocabulary in the easement essentials. So hopefully this code section makes a little more sense. But section 55.1-305, enjoyment of easement. Unless otherwise provided in the terms of an easement, the owner of a dominant estate shall not use an easement in a way that is not reasonably consistent with the uses contemplated by the grant of an easement. And the owner of the servient estate shall not engage in an activity or cause to be present any objects either upon the burdened land or immediately adjacent to such land that unreasonably interferes with the enjoyment of the easement by the owner of the dominant estate. And then for purposes of this section, object does not include any fence, electric fence, cattle guard, gate, or division fence adjacent to such easement of those terms as defined in sections 55.1-2800 through 55.1-2826. Any violation of this section may be deemed as a private nuisance, provided, however, that a remedy for violation of this section shall not in any manner impair the right to any other relief that may be applicable at law or equity. So essentially, this is, again, you see highlighted a dominant estate, a servient estate, all that stuff, kind of terms we've already highlighted. But this kind of gives you like what the responsibilities are of a dominant estate and what the responsibilities are of a servient estate. So you can kind of see it is set forth in Virginia code. It is codified. There is the ability to go ahead and reference this when addressing easements and trying to seek like recovery or damages if easements are not being used properly.
So what would be a real life example of that?
A real life example of what?
Of like somebody using the easement improperly.
So for instance, say you had an easement that was exclusively for the use of accessing a roadway. And then all of a sudden they expanded the property and they were able to create a driveway, so they never needed to use that easement again. So now they started planting plants in the easement because they figure like they want a garden and the driveway was going to be where the garden was going to be, so they'll just switch it and now put the garden on the easement. Well, the easement was exclusively for the use of accessing the roadway and not for a garden, so that's misuse. Things of that nature. So if you truly are having an easement to access a lake, let's see, there's houses and you have a forward house and a back house, and the back house doesn't have access to the lake, but the forward house does. And so there's an easement to allow the back house to access the lake by going through the forward house. And then all of a sudden the lake expands and now the back house has access to the forward house. And the back house decides, okay, well, this is great. Now I'm going to make this a nice walkway. And, that's not necessarily the easement is now being misused because now they're making it a walkway around the lake rather than an access point to the lake. Does that help answer some questions?
I think that clears it up for me.
Okay.
So we have a question in the room, but you may be coming to this since I have a feeling you're going to go through the progression. The question is, can an easement be changed? So
yes, an easement can be changed. Absolutely. It would have to be in writing, and we are going to touch on that. I'm going to have to be in writing and probably be recorded with the court as well. Otherwise, what defaults is based on what's recorded in land records. And if there is any change, then it would have to be recorded as well. So we'll touch on that a little later though. Yes, great question. Forward thinking. All right, creation of an easement. There are several ways you can create an easement. There is express grant, which is created by a writing, and generally that's through a deed or will. And in that regard, a lot of easements you see here in Virginia are through express grant, which is by deed, which we'll touch on in a little bit. You have easement by reservation, and that's created when a landowner conveys land to another, but reserves an easement in it. So for instance, say you have a big piece of land and you subdivide the land. Well, you subdivide the land so one piece of property has a water view and one piece of the property doesn't. The property that does not have the water view may reserve an easement to go on to that other piece of land to go ahead and see the water view or something of that nature. So it's possible in those regards. Then you have easement by implication. So this is when there's no necessarily writing that exists, but it's when certain circumstances occur. And what you often see easement by implication in terms of estoppel. And then we're going to describe what estoppel is. It is a legal term, but it's essentially when an owner of a servient estate may be estopped to deny the existence of an easement by making representations that have been acted upon by the owner of the dominant estate. So what you might see here in this instance is, say you have a seller and the seller represented to this, potential new purchaser, oh yeah, there's an easement, we're allowed to go on my neighbor's yard to go ahead and access the pool, just by way of example. And the seller made that representation, and then all of a sudden, and the seller had been doing it for time and time again, no big deal. And then all of a sudden, the new prospective buyers now own the house, they're now owners. And so they've started using this easement to go ahead and use the pool. And all the neighbors know this to have been happening and all this stuff. And then all of a sudden, the neighbors who have the pool say, absolutely not, I don't know what this is. Well, there is a possibility that by the certain circumstances of surrounding the actions of the neighbors, knowing the prior seller doing this, all the stuff, the current homeowners that have the pool may be stopped from saying, no easement exists. And that's essentially meaning they're precluded. They're precluded from denying that such an easement exists. And this is, again, by certain circumstances. So nothing was necessarily written, but by the patterns and the past history and by actual knowledge of all those surrounding the actual, subject pool and potential easement, they're stopped, and it's easement by estoppel, and that's by implication. There's also easement by necessity. And this comes about when land has been subdivided. So again, let's go back to, you have a big piece of land and you subdivide it by parcel A and parcel B. Well, there may, because it was a big piece of land with one house on it, there may only be one driveway. And so now they're going to build another house on parcel A. Parcel B has the house with the driveway, but there's no other way to make a driveway on parcel A. So an easement by necessity is both of them going ahead and sharing that driveway or something like that. Or if you have one big parcel and there's utility lines, well, if you subdivide the property and the utility box is over here that services both pieces, now you might need an easement by necessity so that the utility company can go ahead and service the electrical box or something like that. All right, and then you have easement by prescription. We kind of touched on this. This is generally an easement by adverse possession. We kind of touched on. This is when easements operate under the presumption of a grant that arises after a long, exclusive, uninterrupted, continuous, adverse, open use of right-of-way on someone else's property. So again, it's hard to prove that. It does happen from time to time. Like I said, though, and kind of highlighted, the issue is how do you prove that it was, adverse and open use if you can't say, hey, I knew of it, but still let it happen type thing. All right, so that's how you create easements. Those are the ways that easements can be created. Again, oftentimes in real estate transactions, you will see an express grant of an easement, which is through a deed, less often through a will, but it does happen. And then implication are surrounding circumstances and actions. Now, how do you get rid of easements? So now we're going to look at extinguishing easements. So one way is the cessation of the purchase for which the easement was created. We've kind of highlighted on this, and I talked about that highway example. So say you have an easement for the exclusive use to access the highway. Well, say the highway was demolished and now they have a different like ancillary roadway. Well, now there's no need for the easement anymore because there's no need to access the highway. It doesn't exist anymore. And you may see these sometimes. So, in Virginia Beach, if you're familiar, they have those feeder roads. Well, they're getting rid of the feeder roads. So this is case in point, a perfect example of cessation of the purchase for which this easement was created. Those feeder roads are no longer. So if there's an easement associated with the feeder roads, the easement's going to extinguish essentially. All right, and then express release. This is pretty clear, but it's when the dominant estate expressly releases the serving estate. So it's the easement holder, the one who's benefiting from the use of the easement on someone else's land that says, hey, I no longer need this easement. And this, again, we kind of highlighted on in the example where you have a house who is using the neighboring driveway to get into their garage, and that's an easement. Well, all of a sudden they have redesigned their house. They've created this open underway so they can do their own driveway on their own property. Well, now the dominant estate may be like, hey, I don't no longer need to use your driveway. I have my own driveway. I'm going to go ahead and expressly release this easement. So there's that as well. And then there's abandonment. That's essentially when someone just stops using the easement, and you can kind of see that by clear and convincing evidence. That is the standard. And that shows up when their weeds are showing up everywhere and you can tell that non-use has occurred. However, with abandonment, you need non-use with acts of intent to abandon. So for instance, you have the non-use, the weeds are showing up everywhere, but that would not be enough. You would need to maybe see like a no trespassing sign, where it shows that there's not going to be ingress and egress on the easement anymore. And it shows like that is an actual intent to abandon it by no one else using the easement. You might also see something where you have a writing with a dominant estate telling the servient estate, I'm moving out of the country and I'm never going to return. So that's an intent to abandon along with non-use, just no use on the property. So again, those are more by, circumstances surrounding the situation. And
can I interrupt you just for 1 second? We have a question in the room from Jimmy Radio.
The express release, can it just be expressed verbally, or does it need to be down at the circuit court?
Could you hear that? If you didn't, Jimmy Radio said, can the express release, can it be verbal, or does it have to be in the actual circuit court?
Great question. So it can be verbal, but it won't have any legal implication for further homeowners on that piece of property. So the best practice would be to go ahead and do another deed of easement, essentially extinguishing the easement. Otherwise, it's just an agreement between you and that dominant estate, in which case, if the dominant estate ever goes and sells the property, in land records, that easement will still show up. And so technically the new owner could potentially claim that easement again.
Thank you.
Thank you.
You're welcome. All right. And then another way of extinguishing easements, which we touched on, are misuses. So this is when the servient owner adversely acts through prescriptive period to obstruct a dominant owner's enjoyment, intending to deprive him of the easement. So again, this is, we touched on this, you build a garden on the easement when it's supposed to be an access point for a lake, or you decide to put a fence around an easement that was supposed to be that access point for the neighbor to get to the garage. Those are misuses, right? That's not what that was intended to do. You're blocking the dominant estate's right to use that servient estate. And it is a right where they can go ahead and try to claim damages through the court on a public nuisance matter. So misuse is a way an easement can be extinguished or modified. And I say it could be extinguished with a misuse, because if the misuse is long enough where no action has been taken, then we go into that, that prescriptive period of time, which is that adverse possession period of time. So these are not seen all the time, again, because that standard and burden of proof is pretty high, but this is an avenue that an easement can be extinguished. You definitely see abandonment and cessation of the purpose for which it was created, and expressly by far more often than you see misuse. And then last one, which you do see in real estate a lot, is the union of the dominant and servient estates. So the same person acquires ownership of both dominant and servient tracts. So this happens when you have a homeowner on home A and you have a homeowner on home B, and then all of a sudden home B is up for sale and homeowner A purchases home B. And so now that's one tract of land, right? I mean, you still have a property line, but it's the same owner. So the owner has permissive use and the actual right to be on property B now that they're owners. So there's no need to have an easement for himself, if that makes sense. So that's when the interest kind of, the easement extinguishes. There's no need for that anymore. And in this regard, the easement would essentially extinguish automatically. So you wouldn't necessarily need to go ahead and require any filing with the court or anything like that. So those are examples of how easements do extinguish. So we talked about, you know, the creation of an easement and then an extinguishment of an easement. And let's go to how to create an easement in real estate. This is kind of probably the big one that we're looking at, and it's going to be on the next slide. So right here, most common way an easement is created in real estate. You will see there are three things: get a survey, deed of easement, and record with court. That's a very, very simple breakdown. So get a survey. Essentially what this is talking to a surveyor and getting a survey of the property and showing where the prospective easement will be. And the surveyor knows how to do this, but kind of like a dotted line with proposed easement or something like that. So there is an identifiable piece of paper that shows where the easement's going to be based on other boundaries and property lines set forth. That is first and foremost. Then once you get that survey, you're going to want to go ahead and get a deed of easement drafted. A deed of easement has certain requirements that you do need to make sure are included with that paper. So some of them are that you describe the servient estate legal description, you describe the dominant estate legal description. And let me preface this by saying, when I say you are not able to draft deeds, right? So I'm not necessarily saying you, but you want your legal counsel, us, an attorney, definitely to draft it for you. But the requirements I'm just going to highlight. So legal description for the dominant estate and servient estate, as well as legal description for where that proposed easement is going to be. It needs to have the use, like the prescribed use of what that easement is going to be, and if there's any duration involved in it. So say this easement's only going to be for the next 40 years. Well, you're going to have, you know, easement for 40 years. If it's going to be indefinite, you'll have an indefinite easement for the use of access to the beach or whatever may be the case, but you'll describe that as well. You'll also have it's signed by the grantor. So the grantor is the one who's going to be the servient estate, who's giving the dominant estate use of it. So it needs to be signed by them as well. So there's definitely requirements, and those are the big requirements. Again, you always talk to your legal counsel and attorney and come to us and draft it, but there are nuances that are involved in that as well. Once that deed of easement is drafted, and another highlight of it is making sure you kind of reference and simultaneously record that survey and attach it as an exhibit to the deed. Once all that comes together, so you have the first step and the second step, now the third step is record with the court. Then you're going to have that deed and survey. You're going to record it with the court in land records, like we talked about. And then that kind of puts the world on notice, and it especially highlights that this piece of property, if you ever did a title search, has this easement. And that is kind of the process to doing that. Now, if you ever have an easement with the city, so sometimes new construction builds, or, you know, say you have an existing neighborhood and a developer knocked down an old home to build a new home, and the old home was serviced by, I don't know, a septic tank. This is just by example. And now all of a sudden they're going to do, you know, they need a, I don't know, a plumbing and drainage easement or something like that. There are cases where that's done with the city. And so you might have an easement with the city. If it's an easement with the city, you will need the city to sign off on it and approve it. So there's some additional steps, but it definitely is something that's done all the time. So that is kind of the
Another
long
question.
Yes.
Another question there.
There's such a thing as a hostile easement in terms of who would be the dominant, wanting an easement on someone else's property and being able to affect it that way? Or does it have to be an agreeable thing? Or does the servient person have to think of it?
So the question in the room is, can there be a hostile easement? So in a situation where the dominant parcel wants an easement, but the servient does not want to grant it?
So yeah, great question. There are they're not necessarily called hostile easements. It would be easement by necessity, where sometimes the serving estate doesn't want to give an easement, but by necessity, it absolutely has to occur. That is something where if you're going to have a serving estate put up a fight saying, no, I don't want to grant this easement, they may try to claim, hey, you're trespassing. I'm going to give you a trespassing notice. You're not allowed to access my property. In that regard, you would probably have to go to court and compel some sort of court order stating that there would be an easement that exists. Oftentimes too, you will have people, owners of the servient estate, be hesitant to grant easements because they don't want, someone just coming on their land and using it without, any kind of say so in terms of what they can say their property is used for. However, they'll say, hey, that's fine. I'll give you this easement if you pay me $5,000. Very common for easements to be purchased. So don't be surprised if you have one of those situations too, which, it makes sense, right? That you would purchase the use of the land, and although you don't own it, you still have the ability to use it. And so you're gaining the benefit. So there's no price point necessarily. Any servient estate is never forced to grant it unless you do have a court order saying you have to have this by necessity. But more times than not, people do understand, and easements by necessity are generally something that have already occurred by this point in time.
In terms of liability, someone getting hurt on your property, if they were to get hurt on that easement of your property that you have no say so in giving them, are you still liable as the homeowner of the servient?
So did you hear that part?
Yeah, no, I definitely agree. So, in the legal world, you can sue whoever you want, right? Whether it's going to be a worthwhile party that you're bringing in is another question. And arguably, from a litigious standpoint and litigation standpoint, they would probably try to bring in the homeowner and bring in whoever, was maintaining that easement, which is generally the dominant estate. So they would try to bring it in. Now, then you would have the arguments of, hey, this was an easement. This was, I'm sorry, it wasn't maintained well, but that was the responsibility of the dominant estate. That has nothing to do with me. I'm the servient estate. And then the judge would likely dismiss you from the case. However, I can't speak on what, certain circumstances under certain cases would compel, because I'm not a judge in that situation, but that is what we would hope for and what we have seen before.
I actually have an example of this. So my personal house, I live in Ocean View. My personal house had a little rundown shack next to it that was a 0 lot line. So it's my house, the driveway, what would have been like a fence, if you will, was literally a little shack. So someone bought the land, was going to tear down the house and wanted to build a new house. The lots in Ocean View, some of these older lots are 25 by 50, right? So they're skinny little things. And so the people were wanting to build a 3-story house on it that was 18 feet wide. And so my thing was, it had to go to the city council because they had to get a conditional use permit to be able to build a house that skinny, because it was going against the coastal district, yada, yada, whatever. So I spoke out against it because I specifically said, they are going to have to come onto my land to do all this. And I'm very concerned about them, and they basically said, figure it out yourselves. So what my husband and I did is we talked to a lawyer, and just like you said, Lindsay, basically it was going to be an easement of necessity because they needed access onto my driveway in order to build this house. They needed scaffolding, whatever. So what we actually agreed to was my husband and I drew up a contract outlining our rights with it, because we were basically not going to be able to use our own driveway for however long they needed to be building this. Isn't it wild? It is. It actually got way dramatic, and I won't go into it. And I called the cops at one stage, but we'll not get into that part. But basically what we wrote was that if anybody was injured, it had nothing to do with us. they were only allowed on our property with 24-hour notice and from such and such time to such and such time. They were allowed to leave scaffolding, but no other equipment. And so we outlined it because the reality was they were going to be granted access regardless. And so in this way, we were able to at least have some control over the situation.
No, and that's an excellent example. I mean, that's real life, right? And in the deed, you can kind of outline too, if you do have an easement by agreement, kind of who's going to be responsible for what and the liability and the indemnifying and hold harmless provisions. You can put all that in the deed as well.
Nikki also had a question.
Yeah.
Oh, so no, we didn't end up asking for money. When we talked to our lawyer, we put in there that we could end the contract at any time, but we did put a deadline. And then if they were to go outside that deadline, then we were able to start charging them. So that was kind of the ins and outs that we did. But they ended up using a ladder, climbing onto my balcony. They ended up bringing a cherry picker onto my driveway with no notice. It was a lot. It was a lot. It was fun. So I have the camera footage if anyone's ever curious.
Oh man, yes, easements can be a load of fun in the true sense and in the headache sense, absolutely. All right, so we've kind of talked about the easiest way an easement is created in real estate. Now let's look at some examples. Easement examples, and we've kind of highlighted this already, but you have utility, drainage, and private. So utility easements, circling back around, does anyone recall what type of easement this would be? Would it be an easement in gross or an easement appurtenant?
Anybody? Go for it. What is it, Lily? Appurtenant.
Nice guess. So it's actually easement in gross. It's easement in gross because it's a personal easement and there's no servient track, right? So I'm sorry, there's no dominant track. So the company has the easement, is allowed to go on the servient track's land, but then the company itself doesn't have land. So it's an easement in gross. Drainage easement is also an easement in gross. Now with drainage easements, what you often see, at least within the last 10 years or so, I would say, is you see easements, drainage easements, I should say, that kind of go along the property line on the sides and in the back with new construction builds and with builds that have occurred within the last 10 or so years. And these are easements that sometimes pools will get built over, which, okay, let's talk about that for a second. Surveys show where easements are, they show encroachments, they show property lines and all that stuff. Oftentimes some people feel like, hey, this is like right in the middle of my property. I know it's within my property lines. I can build something here, which is totally fine. However, if there's an easement that runs under that pool, if there's an easement that runs under the shed or something like that, in the event the utility company or the drainage company or a private easement or whatever needs to access that utility line or the drainage line under where that easement is, they have the right to go ahead and dig up the pool or go right through the shed. So it just gives you, again, the easement is open access without any objects that are interfering, right? We saw that in the code section. So those objects can't be on the easement. Now they can be adjacent if they're in the exception set forth in that code, but you want it to be open and accessible. You don't want to have to block any accesses. So if you do, they can, again, go ahead and kind of demolish through that. So that's why when we look at surveys, we look to make sure, if there are sheds on easements, we always give the clients disclaimers. Hey, shouldn't be a problem, but in the event the utility company or the drainage company needs to access this easement, they may ask you to move it, or they may just go right through it. In which
At
case,
whose cost?
Usually it's at the homeowner's cost because they're the serving estate blocking the dominant estate's right to use the property or the personal easement holder.
And how long does the city have to, so I know that we experience this a lot with utility lines and everything, just in general. Do they have to return it back to how it was prior, and how long do they have to do that?
So it depends on what's set out in the easement agreement, but usually, so this, we're touching on title insurance, right? Owner's title insurance, which I'm always a huge proponent of. If there's a lender involved, lenders require title insurance, but Owner's title insurance generally makes exceptions to easements recorded with the court. So you wouldn't get any recovery from them. The easement, so say you have a gas line that's leaked and they have to dig up your grass or something. They try to get it as close as they can, but that's really the threshold, as close as they can. There's no requirement to make it as though it was before they went ahead and dug up. There's none of that. They just have to get it as close as they can. So the cost really is on the surveying estate, if you will. You can't run from utility easements or drainage easements here in Virginia, unfortunately. And again, they only access it when they absolutely need to. So you'd probably rather have some disturbed grass or a moved shed instead of having your house flood because the drainage line is, the groundwater pushing up and dislodging the foundation of your house or something like that, so they're not going to just access just because. It's always as a need be, worst case scenario basis. And then you have private easements. We've touched on this too. It's the neighboring driveway. It's the easement that needs to go to the lake. It's the easement. Sometimes we do see, and I know I've given this example, which may seem far-fetched, but we do see easements regarding pools. There's an easement from one neighbor's house to another neighbor's house so that they can access the other neighbor's house to use the pool. So we've seen those types of easements too, and that's definitely a private easement. That is not something that's required out of necessity, out of actions, anything like that. So those are kind of easement examples. Does anyone else want to chime in if they've seen anything in their experiences?
We have a question here.
Yeah.
Can they have it? What? I'm sorry. Oh, give a fee if someone's using. Yes, they're asking if you can have, if you're having a misuse of the easement, if you can fine them.
So you would have to probably go to court, and you can't necessarily fine them. They're not obligated to pay for that unless it's spelled out in the easement use. And if there is a misuse, there's going to be a fine of this day or something like that. So if it's spelled out, then yes. However, if it's not something that's agreed to and it's not a term of the deed or the will, if it's an express easement, then you probably have to go to court saying, hey, this is being misused. I want it extinguished, or I want the terms modified, or I want damages for recovery. If they're misusing the easement, you can always go ahead and say, hey, this is not what the easement was for. If this is what you truly do want the easement for, I would be willing to change it for X amount of dollars. And if they agree to that, then you'll just kind of draft up a revised easement deed and all that stuff. But flat out, penalizing them, so to speak, for the misuse, that is not something that you would necessarily be permitted to do unless it was spelled out.
So I have a question real quick. And you may have already gone over this. I had to jump on a call real quick, but as a listing agent, do we have to disclose easements? And then on the other side, as a buyer's agent, if they get a survey and discover that there's an easement that they are not okay with, as a buyer, is that a contingency that they can use to get out of the contract?
Good questions. So as a listing agent, the easements are generally public record, right? And so it could be argued that it's part of the due diligence. It should come up in a title search too. And generally that the easements are show up on surveys. So there's arguments for both ways, right? Do you disclose or do you not? I think it's always better to disclose than not disclose, because you can get into arguments as to whether it's a material misrepresentation or intentional, misrepresentation or whatever may be the case. But like I said, they are public records, so it could fall under the due diligence. So it's up for argument, if you will. And then in terms of your second question, a survey showing an easement that the buyer is just not okay with. Generally not. Surveys just put you on notice of everything, and that at that point in time, it's usually you can't get out based on what a survey says. That's just for information, really. It's not part of the contract, unless, of course, you have a contingency in the contract, contingent on what the survey shows, to buyers' satisfactory liking or something like that. Or upon receipt of survey, buyer has the right to terminate and EMD return to buyer within 1 day. if unsatisfactory or something like that. So you could put contingencies in there, but just by way of having a survey that has something the buyers don't like, it's not necessarily a way out.
So on that same vein, then, if you're saying that it would come up typically in a title search, would you be able to then use the title aspect as a way to get out?
Well,
Almost
easements
like
aren't,
not having a clear title, but not.
easements aren't considered blemishes on title if they are recorded with the court. They are just aspects to, I mean, it's a cloud on title, but it's not a title issue that would prevent a closing from occurring.
So just for a little side note for like the new agents who are either on here or will be watching this later, in the contract, in the purchase agreement, it says whether you waive or desire a survey, that is not a contingency. So just so y'all know that. So when Lindsay says you'd have to actually physically write in there that the survey would become a contingency, because just marking the box that you waive or desire a survey does not create the contingency.
Yes, correct.
I have a question. This is
Yeah.
Lawrence Williams.
Hi, Lauren. Yeah, go ahead.
So, you said that everything has to be like recorded and written and all of that. What if you have a situation where, let's say, some person who owns house A allows the person who owns house B, allows access to them, nothing's written, nothing's recorded, and then the person in house A moves. If it's been, let's say, 10 years, does the person in house B now not have those rights anymore?
So great question. You could argue that it's an easement, but it's an easement by implication, which means an easement by estoppel, right? Based on the circumstances and the actions surrounding it, the new homeowner would be estopped to deny person that was using the property or the servient estate to, cease using it. So there's an argument there. If the new homeowner had no idea and they think, no, this is my property, that's not something that's going to occur anymore, then again, you'd probably have to go to court to establish that by clear and convincing evidence. Does that answer your question?
Yes, it does. Thank you.
You're welcome. All right, easement examples. So here's one. You're thinking about buying a home near a lake on a front lot. And we've kind of highlighted these. So hopefully you'll have answers now. You're thinking about buying a home near a lake on a front lot. There is another house behind it on a back lot that is cut off from the lake. To get down to the shoreline, there is a small driveway running through the front lot and connecting the back lot with the water. So what type of easement would this be? Does anyone know?
We have one necessity.
Yeah, it could be an easement of necessity in order to get down to the water. It's also an easement in grow or an easement pertinent because it runs with the land, right? There's a dominant estate and a servient estate. And in this regard, the back lot would be what? The dominant estate or servient estate?
Dominant.
Correct. And that means the front lot would be?
Servient.
Bingo. Perfect. All right. Excellent. All right. Let's keep going. Time is getting away from us. The electric company has power lines running underneath the land in your backyard. What type of easement would this be?
Utility.
Yep, a utility easement. Would it be in gross or appurtenant?
Gross.
In gross,
Gross.
yes, correct. Exactly. All right. Let's do this one. If someone divides their land and sells a part that is not on a public roadway.
Necessity.
Bingo.
Boom.
And then does anyone have any other ideas as to easements? Well, we had Christy that gave her example, right? We had that easement of necessity. We talked about the shared driveway. We talked about the easement to the pool and all those public easements. Easements are generally more or less the same, right? I mean, there's not any crazy easements you may see. From time to time you may, but again, it's just a non-possessory use to have the rights and use of the land of another. So in any regard that can be. All right, let's move on to easement examples. And I put easement in quotes because these are typically not easements, although they act like easements, and easements could be kind of a potential solution. So we have conservation buffer, which is an easement, and that's essentially lakes, rivers, streams, waterways, anything like that, and conserving that aspect of it. So there are setbacks, there's building setbacks you may see oftentimes on surveys, or you may hear if you're close to water, you can't build certain feet up to the water or something like that. And that's for the conservation buffer. It's not necessarily an easement, but that buffer just allows for conservatives to go in and try to kind of conserve and repair and pour into the environment. Then you have CBPA easement. CBPA is Chesapeake Bay Protection Area. And that is generally saying that you cannot build 100 feet from the main water line. So if you're on the water, if you're on the Elizabeth River, if you're on wherever you may be, generally, again, these are the building setbacks where you can't build from there. It's an unbuildable land if you do own it, all that stuff. CBPA has definitely some requirements and some protections. However, if you're in an IDA is an intensely developed area. There are oftentimes exceptions to that 100 feet build back provision. So that is something to look at. It's not an automatic, hey, I'm in an IDA, so I can go ahead and build within that 100 feet. It's definitely not automatic, but there are exceptions to it where you could potentially. So that's something to look at. But I say it's an easement because you're allowing CBPA to come on to that 100 feet more or less and utilize it. They're not necessarily utilizing it, but they're preventing you from using your land in a rightful way. And then an encroachment. Again, this is not an easement, but an encroachment. A solution to an encroachment is to go ahead and give an easement for that encroachment, if that makes sense. So say you have parcel A and parcel B, and parcel A's fence is encroaching on your land. Well, instead of having parcel A move their fence over to their property line, you can say, hey, I'll give you an easement to allow you to access that sliver of land up until your fence, provided you maintain it and all that stuff. So that's an option too. So you wouldn't necessarily get into an adverse possession claim. A lot of times where adverse possession comes into play is when fences are on someone else's property line for, the prescriptive period of time, open and notorious, continuous, all that fun stuff. Because people sometimes don't get surveys, or they'll stay at their house for 30 plus years and never have to replace the fence, or never realize the fence was always on someone else's lot line or something like that. So these are kind of easement examples that you might see come into play. We will move along to miscellaneous. So maintenance of an easement, we touched on this as well. The dominant estate is generally one that's responsible for the maintenance. In the deed, you can go ahead and include who's going to be responsible and who, indemnify and hold harmless provision and all that fun stuff. Relocation of an easement, we talked about too. Generally, you need another deed again, you can always agree to relocate an easement, right? But you would just need another deed to record it with land records. That would be the most important. And then the cost we talked about. There's no set stone, like, 50 cents per 1 square foot or something like that. There's nothing that gives you a benchmark of what should be the cost of an easement. It's really whatever the surveying estate may want to charge and how badly the dominant estate may want the easement. So that there's that too. There's easements that nothing is charged. People are like, oh yeah, that's fine. Go ahead. I totally understand. Or yeah, no worries. I've got your back. This is a necessity and you wouldn't have any other option. So something like that. It could be as little as $1,000. It could be as much as $40,000. Again, it all depends. More times with utility easements and drainage easements and that stuff, there is no cost, right? Because that's associated with the necessity. But with private easements, the cost may be apparent there. And then questions, comments, or feedback. Does anybody have any of, I know we've kind of answered questions as we've progressed through, but did anyone wait until the end to ask questions? I'm happy to answer them now. If you have comments where you would like to see additional information or feedback, how I can make these presentations better for the next one we do in May, I would love and welcome it.
You have no questions in the room. Anybody online?
No, thank you.
You're very welcome. Absolutely. Well, here's my contact information. If anyone has questions, feel free to reach out. Otherwise, happy St. Patrick's Day. Hopefully you can enjoy the goodies for those in the office today. And I look forward to the next time.
Thank you so much.
Thank you.
You are very welcome. Absolutely, my pleasure.
All right.
Great.